commenced this suit via a complaint dated 1st day of February 2023 and filed on the same date. The general form of complaint was accompanied by statement of fact, witness statement on oath, list of witnesses, list of documents, and photocopies of documents to be relied on at the trial. Following the realization of the change of name of the first defendant, the claimant on 27th day of July 2025 was granted leave to amend its originating processes and reply to the defendant's statement of defense by the amended statement of facts. The claimant prays for the following reliefs. One, a declaration that the claimant as staff of the defendant is entitled to all his outstanding monthly salaries owed him by the defendant from most of September till date. Two, a declaration that the claimant having worked with the defendants for more than 11 years now is entitled to 11 months gross salary at the rate of 70,000 per month as terminal benefit as provided for in the first dependent conditions of service, also applicable to the second dependent. And order three, an order directing the dependent to pay the claimant the sum of 770,000 naira as 11 months gross salary as his terminal benefit, having served the dependent for more than 11 years. For an order directing the dependent to pay claimant the sum of 5,583,450 naira as salary from the months of September 2015 to January 2023. 5, the sum of 5 million as damages. 6, the sum of 1 million as cost. 7, 15% interest on the judgment sum from the date of judgment until judgment sum is liquidated. Upon receipt of the originating processes commencing this suit, the defendant filed memorandum of appearance and statement of defense on 23rd day of March 2023. The claimant in turn filed a reply to the statement of defense and further witness statement on oath on 22nd day of May 2023. On the 28th day of November 2023, the claimant testified in proof of his case as CW1, wherein he adopted his witness statement on oath filed on 1st of February 2023 and his further written statement on oath of 22nd day of May 2023 as his evidence in this case. 21 documents were tendered in evidence and marked as Exhibits A to U. On the 19th day of March 2023, CW1 was cross-examined by the counsel for the defendant. Thereafter, he was discharged. On the 3rd day of December 2024, one Jude Omini Augustine, called by the claimant, testified as CW2. CW2 adopted his witness statement on oath filed on 22nd day of May 2024 as his evidence in this case. On the 5th day of February 2025, CW2 was cross-examined. Thereafter, he was discharged. On 19th day of March 2023, one Jegede Benga testified in defense of the defendant as DW1. DW1 adopted his statement on oath filed on 24th day of April 2024 and as his evidence in this case. Some documents were also tendered through DW1. The facts of the case, I will skip reading the facts of the case. The submissions of counsel, both counsel formulated two issues for determinations. I have captured the argument of counsel on the issues, so I will skip reading them. I will go straight to the decision of the court. Yes, I have considered the processes filed in this suit by the parties, the evidence laid, as well as the written and oral submissions of counsel for the parties. The claimant's claim against the defendant primarily is for payment of arrears of salary in the sum of 5,583,450 naira. Payment of for over 11 years of service rendered to the dependent, 5 million as damages, 5 million cost, and 1 million as cost, and 15% interest on the judgment sum. The law is right that the parties as well as the court are bound by the relief put forward by the parties. The duty of the court is to determine the case in line with the evidence and law applicable to the parties before the court, made available by the parties. The court must confine itself within the relief sought by the parties. See the case of Ekpenyo versus Inyong. See also Obioma versus Olomu. See also Odofin versus Agu. To derive from the relief sought will violate the rights of the parties to the fair hearing, which is a fundamental due trial, and it amounts to acting without due settle that any step taken or pronouncement made without jurisdiction. The defendants on their part have admitted that the claimant the claimant was employed by the first defendant, but denied the claim of the claimant and stated that in 2015 the claimant's employment was converted to fixed term for 1 year renewable. They also allege that his employment was terminated in 2016 and all his entitlement paid as per the letter of termination. They also stated that the claimant cannot sue first and second dependent jointly as they are separate legal entities. The defendant stated further that the claimant's employment having been terminated and terminal benefit being paid to him as per Exhibit D2 letter of termination, he is not entitled to claim for salary arrears till date. Counsel for the defendant has argued that the claimants cannot claim since he is not contesting validity of his termination. According to argue that by claiming terminal benefit, the claimant has admitted termination of his employment in 2016. They also allege that the claimant has not performed any work for them since the termination of his employment for him to earn any salary. For him to claim any arrears of unpaid salary in response to the defendants,
I'm hearing what that's.
in response to the defense, in response to the claim of the defendant that the claimant cannot sue jointly, the claimant stated that he was employed by the first claimant and was posted to the second defendant to perform his duties within the premises of the second defendant. He also denied that his employment was ever terminated by the defendant, as he was never served with any termination letter of 2016. He alleged that the purported letter of termination was procured in the course of proceedings before the court to avoid liability. The defendants have raised propriety of claimant suing the first and second defendant jointly when the two parties are by law separate entities. I have examined the pleadings of the parties on this issue vis-a-vis the submissions of counsel in their final written addresses. What is clear from the pleading and evidence as well as Exhibit B, C, D, G, H, J, K, M, N, O, S, T, U, and D1 is that the claimant was employed by the first defendant to serve as community liaison officer of the second defendant, the subsidiary of the first defendant. From the exhibits refers to above, there is no doubt there is a legal connection and shared responsibility between the two entities concerning employment of the claimant, in that the claimant was employed by first defendant, but the services of the claimant was rendered to the second defendant. This connection has rendered both the first and second defendant liable suable if in event of any breach of the contract of service. This is because it is apparent when there is it is apparent there is evidence establishing the intermingling of operation, common control, and more importantly, second dependent is the beneficiary of the services being rendered by the claimant, i.e., interfacing with community and involvement in settlement of dispute between the community and the dependent. In fact, the claim by the defendant that the claimant was dismissed or was claimant's employment was terminated by the second defendant clearly shows that there is connection between the engagement of the claimant by the claimant and the services rendered by the second defendant. So they all have responsibility concerning control of the claimant. The intermingling of the operations and the common control can be seen with Exhibit I, J, S, T, and DI. In Exhibit D1, the first defendant notified in Shank Village Council, where the second defendant is situated and carrying out businesses. The first defendant notified the village authorities of suspension of operation. Ordinarily, this should have been done by the second defendant itself, but was done by the first defendant. There is also evidence to the effect that the two entities share same offices, secretary and general manager. This goes to show that the operations of the two entities were fused together. This has brought this case within the exception to the doctrine of privity of contract. I therefore overrule the objection of the defendant as to the regarding the joinder of the two parties. The realities in this case point to the fact that both parties should be liable to the second defendant. Both defendants should be liable, as the second defendant is the beneficiary of claimant services. Though his employment was by the first defendant in the circumstances, there is no basis for the defendant to argue that to urge this court to strike out the name of first defendant from this suit, when it was even the first defendant that actually employed the claimant. And from the exhibit tendered and admitted in evidence, the first defendant is the one running the affairs of the second defendant. Therefore, both are suable in this suit. The name of this first defendant cannot be struck out as being argued by the first defendant, I shall now consider the reliefs sought by the claimant from the defendant. Reliefs 1 and 4 will be taken together as they are related. They all deal with the payment of arrears of salary. In this relief, the claimant wants this court to declare that the claimant, as employee of the defendant, is entitled to all his outstanding monthly salaries owed him by the defendants from March to September until date, and to also pay the claimant the sum of 5,583,000 naira for 450 naira. That is the salary from September 2015 to January 2023. It is right to know that whosoever desired any court to give judgment in his favor, whoever desires any court to give judgment as to any legal right or liability dependent on existence of facts which he asserts must prove that those empirical facts exist. See Section 131, subsection 1 of the Evidence Act. In the case of any versus Benue State Judicial Service Commission and others, it was held that the position of the law remains settled that the burden is on the party that assert the existence of particular things or situation to prove same, and he who assert must prove. From the above, it is clear that the law imposes initial burden of proof on the claimant in this case. Then, if the claimant discharges the burden will then will shift to the defendant to prove their defense on the contrary assertion they have made. See Section 134 of the Evidence Act. In this case, the claimant who wants the court to grant him arrears of salary has the burden of proving entitlement to the salary and the quantum he is entitled to. This is because the claim for salary arrears is within the realm of special damages, which must be specifically pleaded and strictly proved. See the case of Filippo versus NNPC. The case of Monica Somil versus Hope has provided guidance to payment of salary. In the case, it was held, I quote, as between an employer and employee, the onus is on the employee to prove that the employer employed him on a stipulated salary and that he worked for the employer during the relevant period. It is for the employer to prove not only that he paid the employee his salary for work done by the employee in the relevant period, but also how much salary that he paid to the employee was. End of quote. In the case at hand, the claimant insisted he is an employee of the dependent to date, performing his duties and is entitled to salary from September 2015 when the dependent ceased to pay him salary to date. The claimant is improving his case relying with the dependent. The dependents on their part are claiming that the claimant was employed as community liaison officer at the request and recommendation of the village council in 2011. The appointment was for a period of 1 year and subject to renewal upon termination. The defendant stated that they will rely on the letter dated 17th day of September 2015, where the claimant's contract was renewed. The letter of 17th day of September 2015 was one of the documents front-loaded by the defendant in their defense, filed on 28th day of March 2023, but they failed to tender it in evidence. However, a photocopy of the said letter was tendered through DW1 under cross-examination. It was admitted in evidence and marked as Exhibit D3. The defendant's father stated that D1 the defendants further stated that the claimant's contract of employment was periodically renewed until 2016 when his employment was terminated. Exhibit D2 letter dated 30th day of August 2016 was tendered in evidence to show that claimant's employment was terminated by the second defendant. They also stated that the second defendant closed down its query site on 19th day of August 2016 as a result of business exigencies and harsh economic environment. The defendant maintained that the claimant employment having been properly terminated and his entitlement having been paid in full is not owed any money whatsoever by the defendants. One of the conditions in the agreement between the defendants and the joint quarrying communities to the effect that every quarry operator within the joint committee must employ a community liaison officer. The claimant also denied his employment being for 1 year and his employment never been terminated. An attempt to put the claimant on a fixed term was resisted and condemned by the Ingachuku Village Council by a letter dated 2nd day of November 2025, which was tendered in evidence and marked as Exhibit T. The said letter of 17th day of September 2016 was withdrawn by the second defendant, and the claimant continued working as community liaison officer of the second defendant in date. To support his case, the claimant tendered in evidence Exhibit K, letter from the village community. The claimant further stated that he was never served with the letter of termination, and that the letter purported contract of appointment, which they claim was for a fixed term, was withdrawn. The claimant further stated that second defendant never closed down query site in Ingachuku village, but temporarily suspended operation and retained core staff, including the claimant and chief security officer, accountant, and human resource manager. After careful consideration of the facts and evidence in this case from both parties and the exhibit tendered and admitted in evidence. I am unable to believe in the line of story being peddled by the defendants in their amended statement of defense that the claimant's employment was for a period of 1 year and subject to renewal upon termination. The reason being that Exhibit D3, which the defendants are placing reliance to support their case, is not capable of supporting their case. The said letter of fixed term was said to have been issued in September 2015. The claimant has denied being served with the said letter. The denial by the defendant, by the claimant of the receipt of Exhibit D3 has shifted the burden of proving that the said letter was indeed served on the claimant to the defendant. However, the defendants have not adduced any iota of evidence showing that the claimant was indeed or actually served with Exhibit D3, the said letter of 1 year term, 1 year fixed term of contract. Even if there is evidence of service or that the claimant has been served, the letter by itself requires the claimant to accept it by signing the acceptance attached to the letter and returning same to the defendant. Therefore, the defendants who have the custody of the acceptance of the offer must produce it before the court for them to establish contractual relationship between the claimant and the defendant. Their failure to produce the said acceptance of the said offer of fixed term and evidence of service on the claimant of the said offer of employment clearly goes to show that there was no contractual relationship established between the claimant and the defendant in respect of Exhibit D3. In the circumstances, I discountenance the position of the defendants that the claimant was employed as per Exhibit D3. On shifting of burden of proof of Exhibit D3 to the defendant, I place reliance on the case of Obayan versus University of Ilorin, where the apex court in unambiguous terms stated that the denial of service of communication on the appellant in that case has shifted the burden to the issue of the communication to prove service. This case is authority that burden shift to the claimant in this case. I therefore that the burden is on the claimant and not on the defendant who asserted effecting service to prove same. The defendants are also placing reliance on Exhibit D2 to show that the claimant's employment was terminated with effect from 1st of September 2016, and by the said letter of termination, claimant had been paid all his entitlement. Having found that there is no contractual relationship established between claimant and the defendant as per Exhibit D3, then there is nothing to be terminated by Exhibit D2. I quite agree with the counsel for the claimant that this letter was in fact a concoction aimed at denying the claimant his entitlement in this case. Assuming but without considering that Exhibit D2 is a genuine letter of termination, the claimant has denied being served with the said letter of termination. He has also denied being paid any entitlement as per Exhibit D2. With the denial of service and payment, the onus is on the defendant to prove that the claimant was actually served or notified of his termination, and he was actually paid what was stated to have been paid to him or to have been entitled by him in the said exhibit. They also have a duty to prove that payment of the said purported entitlement as contained in Exhibit D2. The defendant's failure to prove service of termination and failure to prove payment of what is contained in the said letter Exhibit D2 as claimant's entitlement is fatal to the defendant's defense. Now, having found that the defendants have failed to establish their defense on arrears of salary, I shall determine whether claimant by his pleadings and evidence has succeeded in proving entitlement to payment of arrears of salary from September 2015 to January 2023, when this suit was instituted by the Exhibit B, C, D, Q, R, and U. The claimant was employed by the first defendant as community liaison officer of the second defendant. He has as well by this exhibit established that the stipulated salary on which he was employed, i.e. 70,000 per month. What now remains is to see if the claimant has proved that he worked for the defendant for the period of claim, i.e. from September 2015 to January 2023, a period of 89 months. The claimant has tendered Exhibit F, E, G, H, I, J, and S as proof of work he has done for the dependent. The dependent on their part tendered in evidence Exhibit D1, showing suspension of operation with effect from 19th day of August 2016. There is an acknowledgement at the foot of the said letter indicating that the letter was received by the village secretary on 27th day of August 2016. The dependents have stated that the dependent only suspended operations and retained services of its core personnel, which included the claimant himself, personnel manager, chief security officer, and accountant till date. The claimant stated that letter of 19th day of August 2019, Exhibit D1, was procured only for the purpose of this suit. The further stated that in February 2022, Mr. Binga Jegede came to the query site and met with the claimant and CW2 and even sent 50,000 naira to the account of CW2. The purpose of the meeting was not stated. It is clear apart from Exhibit S, all other documents, i.e. Exhibit F, E, G, H, I, J, and J did not fall within the period of claim of the claimant, as those exhibits covered the period of 2011, 2012, and 2013 only. For Exhibit S, it is not capable of establishing work done by the claimant for the dependent. The said exhibit is letter of authority from the village head to the manager of the first dependent, authorizing him to collect community levies from drivers loading at the second dependent quarry and hand over same to the claimant for onward transmission to the community. This clearly shows that it is not for any work done for the dependent. If there is any work done as per Exhibit S by the claimant, it is a work done to the dependent and not to the claimant. Well, it is work done by the claimant to his community and not to the dependent. Another issue with Exhibit S is that it is original, not photocopy. The letter was not addressed to the claimant, so one wonders how the claimant came into possession of the said exhibit. In the circumstances and in view of the fact that the letter was not coming from appropriate or proper custody, I will not attach any evidential value to Exhibit S, as it is worthless piece of paper deserving is supposed to be in the dustbin. With this finding, there is no concrete evidence apart from said exit of the claimant and exhibits and CW2 called by the claimant to suggest claimant serves the dependent up to February 2022. Let me say straight away that the evidence of CW2 is not helpful to the case of the claimant. CW2 stated in clear terms that on that in February 2022, the claimant, Mr. Binga Jagede and himself met a second dependent query site in Gajakan, in Akampa local government area of Cross River State, where at the meeting, Mr. Binga Jagede sent 50,000 to the second claimant witness through bank transfer. Both CW1 and CW2 have stated in their pleadings that they will rely on the bank statement of account of CW, but none of them has tendered the said bank statement of account in evidence. According to CW2, it was after meeting with Mr. Benga Jegede in February that the claimant informed him that Mr. Jegede offered to pay him less than his accumulated salary arrears, but refused and insist on being paid full salary arrears as dependent community liaison officer. This assertion of CW2 This assertion of the claimant goes to clearly show that he was not at the meeting where Mr. Binga Jagede offered to pay claimant part of his salary as full and final payment, in where the claimant refused, as CWT clearly stated that he was informed after the meeting by the claimant. This clearly shows that the evidence of CW2 is not helpful to the case of the claimant. The claimant in his evidence also stated that in February 22, second dependent site manager Binga Jagede sent the second dependent chief security officer to call the claimant to come to second dependent site at Injigajaku and offered claimant to accept and receive less than his accumulated salary, but rejected attempt to short charge him. He consulted his solicitor to write the dependent letter of demand for payment of his salary arrears in exhibit K, M, and O. This also, let me say that here that I have evaluated the evidence of CW1 and that of CW2 on their evidence under cross-examination. It is clear to me that the holding of a meeting as narrated by CW1 and CW2 with Mr. Binga Jagede cannot prove that claimant has worked for the defendant up to February 2022. The reason being that the claimant in his evidence has unequivocally stated that Mr. Binga Jagede's site manager sent the second dependent chief security officer to call the claimant to come for the meeting. So what it means is that the claimant was not even at the site or at workplace when the meeting was to be held. He has to be called. This means that he has not proved that he has been going to work or proved to have performed any duty for the dependent. But from this evidence, it is clear claimant was not at his workplace when was not as his workplace when the meeting was scheduled to hold. That's why Mr. Binga had to send for him to come for the meeting. This goes to show that claimant did not work for the dependent up to February 2022, not to talk up to January 2023 or to date. After examining Exhibit D1, after examining Exhibit D1, an appraisal of all the evidence before the court, I came to the conclusion that the claimant will not be entitled to payment of salary from September 2015 to 27th day of August 20. I came to the conclusion that the claimant will only be entitled to payment of salary from September 2015 to 27th day of August 2016, when Exhibit D1 was received by the community. I have no doubt in my mind that the claimant is aware of the suspension of the operations of the dependent as per Exhibit D1. In view of my finding, the claimant will only be entitled to arrears of salary from September 2015 to 27th day of August 2016, which is a period of 12 months. Going by Exhibit U, the take-home pay salary of the claimant is the sum of 63,450,000. If this amount is multiplied by 12, the total amount the claimant would be entitled to is the sum of 761,400 naira. I saw fine and hold. Now, relief 2 and 3 are for payment of 770,000 naira. That is being salary for 11 gross salary for 11 months as terminal benefit of the dependent. The claim for the terminal benefit is often tied to the cessation of employment through termination. Resignation is still a staff of the dependent since his employment has not been formally terminated. This presented a potentially a contradiction for claiming terminal benefit, which are typically payable upon termination or retirement from service. However, by claiming terminal benefit, the claimant seems to have considered his employment as having been coming to an end, and by so he cannot be had to assert entitlement of salary up to date. I have already found that his employment was not terminated as per Exhibit D3. This means that there was no formal termination. The mere fact that there is no formal termination does not mean that termination cannot be inferred from the available facts before the court. Given the facts and circumstances of this case, and having regard to Exhibit D1, I have no doubt in my mind the employment of the claimant has come to an end on the 27th day of August 2016. In view of the foregoing, the period of the claimant served the dependent is from 1st day of May 2011 to 27th day of August 2016, which is a period of 5 years, 4 months. According to clause 5.6 of Exhibit A, the conditions of service. An employee that served for a period of 5 years will be entitled to 5 months gross salary. This means that claimant will be paid the sum of 350,000 as 5 months gross salary at the rate of 70,000 per month. Let me say here that by Appendix 2, page 36 of Exhibit A, the condition of service contained in Exhibit A are applicable to both the dependent. These employees of the first and second dependent, they have the same conditions of service. Therefore, the claimant is only entitled to 350,000 as his terminal benefit. I now come to Relief 5, which is for damages in the sum of 5 million naira. The claimant, having been granted his entitlement as per arrears of salary and terminal benefit, is not entitled to damages as he has been adequately compensated by the award made herein, and there is no evidence that he has undergone any disciplinary action wherein his employment was dismissed. Therefore, he is not entitled to any damages. Since he has been paid his entitlement, he has been adequately compensated. To grant him 5 million naira as damages will amount to granting him double compensation, which is the law France Act. I now, therefore, Relief 5 failed same is hereby refused. I now turn to Relief 6, which is for 1 million naira cost. This is granted, the cost is granted at the discretion of the court, having regard to the facts and evidence. In this case, the claimant has not tendered any evidence or proof of expenditure of 1 million naira. In the circumstances, the discretion remains that of the court to award what the court considered appropriate. In the circumstances of this case, I hereby award 300,000 naira cost to the claimant. Against the defendant. For avoidance of doubt, the order of the court is as follows. The claimant is entitled to the sum of 761,400 naira as arrears of salary from September 2015 to 27th day of August 2016. The defendants are hereby ordered to pay the claimant the said sum. B, the claimant is entitled to terminal benefit in the sum of 350,000 naira. The defendants are hereby ordered to pay the claimant his terminal benefit in the sum of 350,000 naira. C, the claimant is entitled to cost which I assess at the sum of 300,000 naira. The claimants, the defendants are hereby ordered to pay 300,000 naira to the claimant as cost. All monetary aspects of this judgment, failing which inter-judgment is hereby entered accordingly. Yes, call the next case.
So my NSCA, class is like 52, like 25. Great availability of and 1, the Nigeria Police Force. 2, Inspector General of Police. 3, Commissioner of Police, Cross River State. 4, Governor of Cross River State. 5, Governor of Cross River State. 6, Deputy Governor of Cross River State. 7, Attorney General of Cross River State. 8, Dr. Justin Boche, Cross River State, Commissioner for Science, Technology, and Innovation. 9, Police Service Commission. Ballot parties are absent.
Appearance. Appearance. Agrinya appearance.
Lord be pleased.
With profound
My Lord,
respect,
Lord be pleased. My Lord, F. Baba Isa for the applicant, my Lord.
Yes.
with profound respect to my Lord,
Yes.
Udeni Wamaji appears for the 4th to 8th respondent.
Yes.
Udeni Wamaji, my Lord, Deputy Director, Cross River
Yes.
State Ministry of Justice, for the
Yes.
4th to 8th respondent.
Okay.
Thank you, my Lord.
Yeah, okay. Yes, this is the judgment of the court. The judgment of the court on on the 28th day of April 2026, after argument by counsel for both sides on the originating motion, judgment was fixed to be delivered on the 11th day of June 2026. However, the judgment having been ready, I directed the registrar to brought the date forward and fix it to today for delivery. The judgment goes like this. This deal with originating motion dated 20th day of October 2025 and filed on the same day. The motion was brought pursuant to section 34, 35, 37, and 41 of the Constitution of the Federal Republic of Nigeria 1999 as amended, or that 1, 2, 3, 4 of the Fundamental Rights Enforcement Rules and People's Rights Certification and Enforcement Act, and under the inherent jurisdiction of the court. The application is praying this honorable court for grant of the following reliefs. They are: 1, a declaration that the post-8th respondent have no right in law to use the police, that is to say, the first to third respondent and other agents and operatives to invite, chase around, harass, seek, to arrest, detain, humiliate, dehumanize, and oppress the applicant with respect to the parts of this case, which are purely civil matters bordering on labor, stroke employment matters. 2, a declaration that all the invitation extended to the applicant by the third respondent at the instance of post-X respondent, in respect of the parts of this case is null and void, and in violation of the applicant rights to dignity, human person, personal liberty, privacy, and movement. 3, a declaration that the detention of the applicant from 28th to 30th day of August 2024 by the third respondent agent of the first, second, and ninth respondents at the instance of the post-8th respondent in respect of the parts of this case are unconstitutional and in violation of the applicant rights to dignity of human person, personal liberty, privacy, and movement. 4, a declaration that given the circumstances of this case, it will be a contravention of the rights and to dignity of human person, personal liberty, privacy, and movement of the applicants if the first to third respondents use their agent, operatives, and servants to invite, chase around, harass, seek to arrest, detain, further detain, humiliate, dehumanize, and oppress the applicant over the facts of this case. 5, an order of this honorable court nullifying all the invitations extended to the applicant by the first to third respondent at the instance of post-8th respondent. 6, an order of perpetual injunction restraining the respondent, their agents, servant, previous, or successors, howsoever, from inviting, arresting, further arresting, chasing around, detaining, dehumanizing, oppressing, or in any way violating the fundamental rights of the applicant in connection with the facts of this case. 7, an order directing the respondent jointly and separately to pay the applicant the sum of 5 million naira as general damages. 8, an order directing, 5 billion naira as general damages. 8, an order directing respondents jointly and severally to pay the applicant the sum of 50 million naira as cost of litigation. 9, any other applicable reliefs as may be just and applicable in the circumstances. The grounds of seeking of seeking the above reliefs are as contained in the motion papers are as follows. I will keep reading the grounds. I will also skip reading the facts as submissions by the claimant as well as those by the defendant. I now go straight to the judgment of the court. When counsel gets the hard copy, they will see the argument as captured. I have considered the originating motion commencing this suit, the counter affidavit filed by counsel for the post-8th respondent, the further and better affidavit, the written address file along with the processes filed by the parties, as well as having attentively listened to the oral submissions of counsel for the parties in adumbrration of their respective position of their client. The first to third respondent, as well as the ninth respondents, did not deem it fit to enter appearance or file counter affidavit. The oral submission of counsel for the post to its dependents, respondents, has raised a very fundamental issue that need to be determined before dealing with the originating motion. On the 28th day of April 2026, when the originating motion was argued by counsel for both parties, the learned deputy director appearing for the post to its respondent, a reply to the further affidavit, a reply on point of law by the applicant, has made some far-reaching argument bordering on admissibility of exhibits attached to further affidavits, the authenticity of signatures on the affidavits of the applicant. The learned deputy director has also argued that the crux of the claimant's case has nothing to do with pension and retirement. The claim of the applicant cannot be determined in this case as it cannot be anchored on any reliefs. The reply by counsel for the applicant in response to the oral submissions of counsel for the post to its respondent centers on the argument on authenticity of signatures of the affidavit of the applicant. Counsel for the applicant insisted, while relying on case law, that there is nothing wrong in a party having two signatures. Consequently, counsel asked the court to discountenance the submissions of counsel for the post to its respondent on authenticity of the signature of the claimant or the signature of the applicant. However, there is no reply by counsel for the applicant on the submission that the applicant case has nothing to do with issue of pension or retirement, and that the claim of the applicant cannot be determined in this suit. To me, to my understanding, the submissions of counsel for the claimant clearly challenged the competency of this suit. Therefore, the underpinning challenge being thrown up by submission of counsel for the first to eight respondent is that this court does not have the requisite jurisdiction to entertain this suit as it is presently constituted. Even if I am wrong in my conclusion on the submission of counsel, the law has adequately to determine issue of jurisdiction for motor, though result of the originating motion and all the processes filed by the parties as well as oral submissions of counsel. What agitates my mind is whether the applicant's case, as it is presently constituted, is properly before this court. In other words, the fundamental question that need probing is whether this court has requisite jurisdiction to hear and determine this suit. The term jurisdiction is varied and ubiquitous. That's why it has been variously described as light wire of any case. The authority of a court to determine any dispute tabled before it by contending parties. Hence, the law compels a court to treat first an issue of jurisdiction where it is raised in any proceeding or so motor by the court. In essence, jurisdiction denotes a court's power to decide a case or issue a decree. See the case of RSHA, Rivers State House of Assembly versus Government of Rivers State. The issue of jurisdiction is very vital and fundamental in Nigerian jurisprudence, and a judgment or order of court given where such a court lacks jurisdiction is a nullity. See Madukolo versus Nkendeli. See also the case of UBA PLC versus Trident Consulting Limited. One important realization is that the jurisdiction of a court is not a matter of conjecture or convenience. It is a strict question of law that must be properly established. The question of jurisdiction is never a mere technicality. It is a substantive issue that strikes at the core of adjudication. That's why the jurisdiction of a court being a hard matter of law, it can only be determined in the light of enabling statute or constitutional provisions conferring jurisdiction on the court in question. In any event, a court of law cannot add or subtract from the provisions of a statute or constitution. As a matter of law, a court must blindly follow and apply the jurisdictional limit and limitations as contained or provided for in a statute or constitution. In that and other situation, the constitution or statute is the master, and all that a court of law can do is to interpret the provisions of the constitution or a statute to obtain or achieve clear intention of the lawmaker. A court cannot do more than that. See the case of Ambassador. So in the case of Anibi versus Short May. See also Elelu Habib versus Attorney General of the Federation. See also Madumere versus Okwara. See also Okwara versus Amadi. See also Standard Alliance Insurance Company Limited versus FCMB. In order to establish that a court has jurisdiction over a matter, it must be shown that it is properly constituted with respect to the number and qualification of its members. The subject matter of the action is within its jurisdiction. The action was initiated by due process, and any condition precedent to the exercise of the jurisdiction, exercise of its jurisdiction has been fulfilled. See Madukolo versus Nkendele, Supra, see Attorney General of Lagos versus Eco Hotels Limited. See also Leodro Presidential Motel Limited versus Bank of the North. See also AfriBank Nigeria Limited versus CBN. Before proceeding with determination of jurisdiction of this court to hear and determine this suit, let me say that if it is taken that none of the parties has raised the issue of jurisdiction of this court, I will say that the well-settled principle of law is that generally no court possesses the power to raise an issue so moto and therefore thereafter proceed to determine it without first inviting the learned counsel for the parties to address it on the issue, as that would amount to denial of fair hearing. However, there are circumstances recognized by our law in which a court of law effectively raises an issue suo moto and determines the same issue without hearing the parties, particularly if the issue borders on jurisdiction of the court and on law. As in this case, the court can take judicial notice of same. See the case Omokuajo versus Federal Republic of Nigeria. See also Adeli Bibe versus Abidoye. See also versus Cross River State Independent Electoral Commission. See also Bank INEC versus Oba Dibo. See Gwede versus INEC. See Egucho versus CCMB. See Odedo versus Ogwebo, and host of other cases cited therein. In situations related to the jurisdictional competence of a court to entertain a matter, it has been an established principle of law that a court can so moto raise the issue of jurisdiction and deliberate on it without first calling the counsel to parties to address it on that. The rationale behind this principle is rooted in the fact that a court must have jurisdiction over any proceeding before it. Otherwise, it labors in vain, and all it does amount to a nullity. In other words, the issue of jurisdiction is very paramount and crucial. It can be raised at any stage of proceedings and even on appeal before the Supreme Court. As a result, where at any stage sufficient facts or materials are available to raise the issue of jurisdiction, or it has become apparent to any party to the action that it can be conversed, there is no reason why there should be any delay in raising it. Furthermore, the issue of jurisdiction can be raised in any form by any of the parties or so moto by the court. See the case of Shelling versus Bola Gobank. See also Elabanjo versus Daudu. See Jeric Nigeria Limited versus UBN. See Labour Party versus INEC. See APGA versus Anyao. See NDIC versus CBN. Having established the bias of this court to embark on the voyage of determining whether the present suit is competently before this court, I shall proceed to examine issue of jurisdiction in respect of the present suit. As pointed out earlier in this judgment, a court of law is said to have and possess the requisite jurisdiction to entertain and adjudicate over a cause or matter when it is properly constituted as to the number A qualification of its members, and any condition precedent for the exercise of the said jurisdiction has been fulfilled or satisfied. B, and the subject matter the subject matter and parties are within the jurisdiction of the court, and the cause or matter has been brought to the court by due process of law as provided for in the Constitution or the relevant statute. The subject matter and the parties of the action are within its jurisdiction. In a matter, woman, in a case to be decided on affidavit evidence, like in this case, what the court consider is the SCC Nigeria Limited versus George, Nigeria Limited versus Joseph. See also Elegbe and another versus HP International School Limited and others. The counsel for the claim and originating by an originating motion. The originating motion was said to have been brought pursuant to section why court is the when court determine which then call upon to look at the law vis-a-vis the pleadings in the affidavit which stand as the pleading and the relief sought. See if this submit resolution comes within the ambit of its jurisdiction as provided by the Constitution or statute, as the case may be. In the instant case, the relief sought by the applicant and the facts deposed to in the affidavit, the applicant is contesting the validity of his arrest, detention, is contesting the validity of his arrest and detention and harassment by the police from 2024, which he asserted was at the prompting of the ex-respondent petition to the police. The affidavit evidence has also disclosed that the claimant resigned with the respondent. Consequently, they have no power over him or pushing him or instigate the police to detain him under the pretext of investigation of vandalism, which was linked to the applicant by his originating motion is alleging violation of his fundamental right. Assigned in Chapter 4 of the Constitution of the Federal Republic of Nigeria as amended, in that he was allegedly arrested, detained, harassed, and his right to be a person violated because he was unable to meet with the demand of money by the respondent when the applicant, the original of in fundamental right processes is done by support of the Constitution of the Federal Republic of Nigeria as amended by virtue of Section 46, subsection 2. Any person who alleges that any of the provisions of Chapter 4 is being or likely to be contravened in relation of the state for redress, subject to the provisions of the Constitution, a High Court shall have original jurisdiction to hear and determine any action made to it in persons of this section, that is Section 6, and may make such orders, issue such writ, and give such direction directions as he may consider appropriate for the purpose of enforcing or securing enforcement within the state of the right to who makes the application may entitled to under the provisions of 46 subsection 1 of the Constitution grant prospective or actual victim of fundamental rights abuse and fettered access to a high court for redress. The high court in this case means the state high court, Federal Capital Territory, and the Federal High Court. The case of SCC Nigeria Limited versus Joe. It is clear from the above provisions of the Constitution as by the apex court that in application imposed right, irrespective of the subject matter and the parties, both the court, before the court, the High Court, the High Court of Federal Capital Territory have concurrent jurisdiction on enforcement of fundamental rights. This is because Section 46 of the Federal Republic of Nigeria, as amended, refers to a high court as of a state without any restriction. In other words, the provision ensures access to any high court as long as it is within the state in which the alleged infraction. What is important is that the grievance of the applicant is the breach of fundamental right protected under Chapter 4 of the Constitution and not veiled attempt to seek redress for other generic civil rights, employment, property, or trafficking, etc., under the guise of enforcement of fundamental rights. The rationale behind the approach is that because of the essential fundamental rights, which must be guarded of a citizen seeking to enforce his fundamental right, there is no ambiguity in the provisions of the Constitution or of the fundamental right enforcement procedure rules regarding which court has jurisdiction and application of fundamental right. See the case of SCC Nigeria Limited versus John. See also Rene. See also Generally, fundamental human rights are provided for under Chapter 4 of the Constitution of the Federal Republic of Nigeria, subsection 1, therefore, provides that any person who alleges shall approach the state. The Constitution created both the High Court, the court enjoy unlimited jurisdiction, subject to provisions 1 of the Constitution and any other provisions thereof, and in addition to such other jurisdiction as may be conferred upon them by the Act of National Assembly. It is against the above background, I now consider the jurisdiction of this court to entertain matters bordering on violation of provisions of Chapter 4 of the Constitution as amended, as in this case, Section 251 provides, notwithstanding the provisions of Section 251, 251, 257, 272, and anything contained in this Constitution, and in addition to such, may be conferred upon it by National Assembly. The National Industrial Court shall have and exercise jurisdiction to the exclusion of any other causes and D, relating to or connected with any dispute over interpretation and application of the provisions of Chapter 4 of the Constitution as it relates to any industrial employers association or any other matter of the Constitution of the Federal Republic of Nigeria as amended has clearly and unambiguously provided for the jurisdiction of this court as enforcement of fundamental rights according to the Constitution. The first part meant that the National Industrial Court can any suit in which any provisions of Section 33 to 46 of the Constitution would be interpreted or applied on the second as to any employment. The operative price is as it relates to, and to the relevant question asked is whether the claim before the court in this case is adumbrated by the release being sought a defendant. Consequently, Section 254C1D of the Constitution confers jurisdiction of this court to the exclusion of any other court of coordinate jurisdiction on dispute calling for interpretation or application of fundamental rights provisions in relation to employment and labor matters. See the case of SCC Nigeria Limited by Sis George. I have scrutinized the 9 reliefs being sought by the applicant. In this case, they do not seem to me, they do not seem to be within the purview of exclusive jurisdiction of this court under section 254 C1D of the Constitution as amended, or within section 71 of the Industrial Court Act. The reason being that the reliefs are for violation of the applicant's fundamental rights as enshrined in section 34 to 35 of the Constitution as amended. It is to be noted that the mere fact that an allegation of violation of fundamental rights were ordinarily made in a context of employment does not without more transmute such a claim into a labor or employment dispute within the contemplation of section 254C of the Constitution. The only way such an allegation can be accommodated is if the alleged violation of right comes as an ancillary claim to labor or employment matters, and the court, from the facts assessment, it to be an inextricably tied or bound up within the main claims before the court. The court can accommodate it under section 254C1D as a cause or a claim connected with labor matter. See the case of Bono versus Borno State Radio Television Corporation, where Igu JSCL as his own of blessed memory. The law is now settled that where ancillary or incidental claim or claims are inextricably tied to or bound with the main claim before the court in a suit, a court of law cannot adjudicate over them where it has no jurisdiction to entertain the main claim. If such incidental or ancillary claims cannot be determined without a determination of such incidental or ancillary claim, must necessarily involve in consideration or determination of the main claim. See the case of Alhaji Umaru Abba Tukur versus government of Gongola State. See also Alhaji Umaru Tukur versus government of Taraba State and others. The Apex Court has recently settled the jurisdiction of this court on fundamental right as encapsulated in Chapter 4 of the Constitution. In its decision in the case of SCC Nigeria Limited versus George Supra, SCC Nigeria Limited versus Joseph Supra, and the recent one in 2006 in Elebe, and another versus SP International School Limited and others. What these authorities establish is that for this court to have jurisdiction over fundamental rights in Chapter 4 of the Constitution, the dispute must be labor-centered. Must be labor-centered dispute or employment-related in substance. In such cases, jurisdiction is exclusively reserved for the National Industrial Court of Nigeria. Irrespective of how the claim is framed, no other court may validly assume jurisdiction over such matters, and any proceedings commenced elsewhere are constitutionally incompetent. The jurisdiction conferred is both substantially arising from labor or employment, but also all matters relating to connected with incidental to or arising from employment relationship and workplace. The law does not allow any interpretation that would introduce ambiguity and distort the careful constitutional allocation of judicial powers, with the attendant risk of undermining the clearly demarcated jurisdiction of the superior courts of record. Such an approach would also engender doctrinal uncertainty, as litigants may deliberately camouflage ordinary civil claims with the banner of employment relationship in order to improperly invoke the jurisdiction of the court. For avoidance of doubt, the matters intended by the legislator to be vested exclusively in the National Industrial Court are labor and employment dispute, strictly so-called, and any civil violation, causes of action merely arising in an employment setting is not within the jurisdiction of the court. In the instant case, a careful examination of the originating motion and the supporting affidavit reveals that applicant's cause of action is founded on alleged violation of applicant's fundamental rights to personal liberty, dignity of human person, which are fundamental rights contained in Chapter 4 of the Constitution. The reliefs are neither predicated on any contract of employment nor on the enforcement of any conditions of service. The mere fact that in the alleged violation of right, the applicant made reference to his resignation, retirement, retirement, and receiving pension in respect of his employment does not without more transmute the claim into a labor or employment dispute. What is decisive in the determination of jurisdiction is the substance of the claim, and the nature of the relief sought, and not any attempt by a party to color a purely enforcement of fundamental right with employment-related considerations. When there was no relief or conditions of service, there was no relief on condition of service or on payment or non-payment of terminal benefit, such as gratuity, pensions, or any other benefit. The applicant has not proved any basis for invoking the jurisdiction of this court in respect of the claim wholly unconnected with labor or employment relations. Accordingly, the respondent's cause of action, the claimant's cause of action being one in fundamental human rights violation falls outside the purview of jurisdiction of this court. Therefore, this court lacks requisite jurisdiction to entertain this suit as it is presently constituted. From all I have been saying above, the applicant has not properly commenced this action as he approached a wrong court for redress. The subject matter having not been within the purview of the jurisdiction of this court lacks the requisite jurisdiction to entertain this suit. By the provisions of Section 24 of the National Industrial Court Act, where an action is found not to be within the jurisdiction of this court, where an action brought before the court was found not to be within the jurisdiction of the court is statutorily empowered to transfer the suit to the appropriate court having jurisdiction instead of striking out this matter. In abiding by the tenet of Section 24 of the National Industrial Court Act, and having regard to the parties relief sought, the appropriate court vested with the jurisdiction to deal with the dispute in this case is by virtue of Section 251 of the Constitution as amended the Federal High Court. In the circumstances, I hereby order transfer of this suit to Federal High Court, Calabar Division, for hearing and determination. The registrar of this court is hereby directed to act accordingly and transfer the said matter to the Calabar Division of the Federal High Court for hearing and determination. Judgment of this court is hereby entered accordingly.
The court pleases. My Lord, we want to thank my Lord most especially for my Lord's well-considered decision. May God continue to bless the court, and we wish the court all the best, sir.
Thank you.
My Lord, I thank you for the judgment.
Yes. You are welcome.
Thank you, my Lord.
Thank you, Counsel, for being with us. We have come to the end of today's virtual sitting. Administrator, you can discontinue with the sitting.
Thank you, my lord.
Thank you, madam.
Okay.
Serious.